Alrighty, folks, we are live. I am George with Solo, and this is the Debt Hotline. We're here with my friend Ben.
Hey, everybody.
Added Ben Jackson with Upsolve. Ben, can you tell us a little bit about yourself?
Yeah, I feel like I should start with telling people who've seen me on the internet before why I'm not wearing an Upsolve shirt. It's too hot and I can't find any t-shirts, so I had to take my sweatshirt off. I promise I sometimes look more brand appropriate. So I am the co-founder and chief operating officer of Upsolve. We're a nonprofit that helps people get out of debt through Chapter 7 bankruptcy. I do this because bankruptcy saved my life. I was in a position where I had $60,000 of debt, was making $20,000 a year. The math didn't work, right? Like I was paying almost my monthly income just on interest payments, and my debt was just getting bigger to the point where I actually ended up on food stamps. So bankruptcy allowed me to get a fresh start, to get back on my feet, and then eventually go to law school and found Upsolve to help other people find that same freedom. So I do that all day, every day. I love it. We have free software that's kind of like a TurboTax for bankruptcy. It helps you file bankruptcy from start to finish, soup to nuts, for free, if you're eligible for that. And I have just found out the other day, actually, George, that we have helped 14% of the total people in the US who've filed bankruptcy
Alrighty,
in the
folks, we are
last
live.
2 years, which
It's
is absolutely insane. So we've done this a few times, and I'm happy to answer any questions y'all have about bankruptcy.
14% of all people who have done bankruptcy have been helped by Upsolve in some way, huh?
Chapter 7 bankruptcy. Yeah, pretty wild.
That is fantastic. Love it. Love hearing that success story, Ben. That is fantastic. Yeah. So, folks, if you are considering bankruptcy, right, Upsolve is a great way to do it. You really can't beat doing Chapter 7 for free online. Can be a great move. So, a lot of you guys have come here. You found out about Solo because you've probably been sued for debt, right? So you can use Solo to respond to the lawsuit. Then you can also get the debt settled. So if you'd like to go debt settlement route, not a traditional debt settlement route, but you can use our tool Solo Settle to get that done. All right, folks, we're going to be talking a little bit about a Q&A on bankruptcy and how to do that for free. As we've mentioned, Upsolve is probably the best way to do that. Ben, is Chapter 7 always free?
It's a good question. So Chapter 7 by itself is not free. You're going to have a filing fee that you'll need to pay. You can get that waived very often. And I can't find any. You are below a certain income. Lots of Upsolve users get that waived when they file, and our tool can help you do that as well. What tends to happen, though, when people file Chapter 7 bankruptcy is they end up paying a lawyer. That was something that I almost did when I filed before I realized I could do it myself. And those fees, depending on where you live, will be anywhere between like $1,500 and $3,000 to prepare those forms and to file them for you. But if you do it yourself, you just have to pay the bankruptcy filing fee.
Fantastic. So if you do those forms yourself, you just have to pay the bankruptcy filing fee. How much is that usually?
You are scraping the bottom of the barrel of my mind. I believe it's just updated to $338 for Chapter 7. So $338 this year. Chapter 13, which is a different type of bankruptcy where you're on a repayment plan, is $313 for your initial payment.
Okay, so around $300, not too bad to be able to discharge and essentially delete thousands of dollars of debt. And people are oftentimes deleting how much in debt in Chapter 7 is $10,000 of debt. It was $100,000.
So the average Upsolve user has $48,000 in debt, which if you're just making minimum payments on $48,000 in debt, that's going to, take you over 80 years to pay off. A lot of people don't realize that because of the way the interest accrues. And you're going to end up paying not $48,000, but around $165,000 in total interest over the course of those payments. So we save people about $48,000 of debt and then $115,000 or $114,000 of interest over the course of that debt's life.
Interest really adds up.
It does.
That's for sure. That's why you should always be interested in the interest.
I love it. Make your money work for you and not for the credit card company.
Exactly. Okay, so Chapter 7 isn't always free, right? You have to pay at least the filing fee, but you can get that waived. Oftentimes people will pay an attorney. And then you can use Upsolve where there aren't any other added fees, right? It's basically just the filing fee.
Yep, 100%
Um,
free.
there's also like there's like pro bono options out there as well, where you
Yep.
can go through like a help organization, right?
Yep, absolutely. You can often find those if you go to like your local bankruptcy court. Court clerk will have some references. You can also go to lawhelp.org and you can search for bankruptcy lawyers near you. There's usually free what's called pro bono support. Our tool can also help you get connected to a lawyer that will do a consultation with you for free if you're not comfortable doing a bankruptcy filing, or if it would be risky for you because you have assets you need to protect. So if you do want to talk to somebody, our tool can help you connect with them as well.
Nice. Yeah, that sounds like a great move. All right. Well, cool. So we have a question here from a friend of Solo. It's Phil in Oklahoma. Howdy, Phil. If you're on the show live, um, go ahead and just let us know in the comments here. And folks, we reserve a bit of time on the show for any live questions that people have. So feel free to put your questions in live into the comments here on YouTube where we're doing the show live. So Phil says, the only thing keeping me off the street is my home.
Hmm.
It is just a trailer house on undeveloped land,
Hmm.
but I do worry about it being taken.
Hmm.
So pretty hard times for Phil.
Yeah, I'm really sorry to hear that, Phil. It sounds really stressful.
Indeed. Sorry to hear it. Indeed, Phil. It is paid off in full along with the land. That's a good spot to be in, right?
Mhm.
Good spot. Paid it off. That's great. Good job, Phil. And it's probably only worth around $50,000,
Okay.
which is also about how much debt I am in.
Hmm.
My debt problem began when I went off my meds for ADHD
Oof. Been
while
there.
ending a very toxic relationship.
Hmm.
And those meds can have a big impact on people's brains,
Yes.
that's for sure. And that was amplified by having a mini stroke.
Oof. Whoa. Phil. Man, life has not been easy, my man.
Double whammy. Before then, I was very good at handling money. That's good to hear. Probably paid off the property during that time, I'd imagine, and staying out of debt. Having been homeless for many years before this, I know I cannot go back on the street.
Hmm.
So this is a very big problem, a very big concern for me,
Hmm.
even though it may be small to most people. Um, I don't know. I don't know if it is going to be small for most people. It seems like a pretty big deal,
Yeah.
right? I think,
Yeah. No kidding.
50K of debt, if you owe 50K of debt, that's not small. Right, as Ben was just saying, right? Most people on average is 48,000
Mhm.
in debt on Chapter 7 bankruptcy at Upsolve. Um, so it's not small, especially losing your home. Losing your
Mhm.
home's big as well.
Yeah, definitely. Yeah.
Yeah.
Phil, can I don't know if he's on the call. Did we figure out if he's on with us?
Uh, let's see. I'm not seeing him. I'm not seeing
Okay.
him on the call now.
Let's frame this in two different ways. We don't know if there's a debt lawsuit, it sounds like, right?
Uh, let's see. I believe that he is being sued.
Okay.
Yeah, he's being sued actively for one of the debts. He says, "I
Okay.
have nothing else of value. I do
Got
want
it.
to thank you all for help." Uh,
Got it.
yeah,
Okay.
yeah. So he used Solo to respond to the
Okay.
lawsuit so far.
Got it. Got it. All right. So why don't you answer what would happen with his home or what's likely to happen with his home if he is to settle this, and I can talk a little bit about what would happen in bankruptcy.
Yeah. Yep. So Phil, good job taking the first step, which is responding to the lawsuit and protecting your assets in that regard. And from the Solo perspective, what we found is that most of our people want to settle the debt, so they come into us to respond to the lawsuit, and then they can get it settled.
Hmm.
And so we think of like responding to the lawsuit as a step towards settlement. Kind of gives you the leverage needed to settle, and then we connect the collector and the consumer amicably
Hmm.
for the purposes of getting a deal done
Hmm.
quickly. Uh, so if you owe $50,000 in debt, uh, the one that you're being sued for, you might be able to get it settled for like 70% of the balance. So if it's $10,000 debt, you might be able to get it settled for like $7,000. The ones that are pre-lawsuit, so you haven't been
Hmm.
sued for, you might be able to get those settled for around 45%. So if you owe $10,000, you might be able to get it settled for like 4,500. And on settlement, you have like a range of options. You might be able to do a lump sum payment where you pay like $7,000 to settle a $10,000 debt all at once. Also, you might be able to just get it on monthly payments. So we kind of have like two kinds of people that come to us. One is somebody who wants to get the savings and they're able to pay the money up front to get that savings. And then the other group is people who want to get onto the lowest monthly payment. And that's kind of where things are, right? Oftentimes collectors will be pretty happy to take a pretty low monthly payment over time. And something that's nice is when you're being sued and you settle, usually the debt will be stayed. That's usually a pretty solid term that we're able to get for you with Solo. So you won't have an additional interest. Whereas if you lost the lawsuit or like don't settle, just keep on going, you'll probably pay at least an additional 70%. Very, very conservative estimate, at least additional 70% on top of what you're being sued for. Yeah, that's kind of a rundown. Yeah, been good.
Yeah, what state were we in here?
This is Oklahoma.
Okay. All right. So I'm asking because what would happen in bankruptcy is kind of going to depend on where you live. So really, really high level rundown. When you file bankruptcy, you get appointed a court trustee who decides what of your things can be sold to pay back your creditors. Now, they can't sell everything. There are certain things that the court protects. Like the court doesn't want you to be homeless. The court doesn't want to come take your clothes and your couch and very often your car. And so there's these things called exemptions. And those exemptions vary on a state-by-state basis, or you can pick the federal exemption. So if you file bankruptcy, whether and how much of that $50,000 of value that you have in your trailer, Phil, you can keep is going to depend on whether or not it's covered by the bankruptcy exemptions in your state. So just looking into this at a high level, I believe, let me just look at Oklahoma's exemptions. So the thing that would be different in Hawaii versus the other states would be the different exemptions that you have. So let me actually pull this up. And George, if I share my screen, is this going to cause a problem and all hell's going to break loose technologically?
Yeah, probably don't share your screen. Yeah.
Okay. I won't. I'll send it over to you and you can drop it in the chat later. But if you go to, let me find the article URL, Hawaii Exemptions Bankruptcy Upsolve, you can search that on Google. We have an article called What are the Hawaii Bankruptcy Exemptions? And it'll walk you through that step by step. I'm sending it here to George in the chat. Won't share screen because I don't want us all to enter into the matrix. But there's Hawaii and there's Oklahoma if we want to share that later. But yeah, in general, same bankruptcy laws, just different exemptions, which means different values of property that can be protected.
Right. Great. Okay. Yeah. So it looks like, yes, folks, just recapping there. Hawaii has different bankruptcy exemptions. However, it's the same bankruptcy law because bankruptcy law is federal.
Exactly. And I just made my way into the chat on YouTube, so we'll double team this, and I'll send those links over there.
Yeah. Okay. Great. Yeah. Looks like we're having a little bit of technical difficulty here, but I think we're getting things back together.
No problem.
On the webinar. Okay. Going into the next question here. So we have Pedro in Tennessee. I filed a motion to compel arbitration for debt that is $1,600 with Midland Credit Management. But even though the collection agency and I showed up in front of the judge, he offered me a payment plan, which I rejected, and told him that I filed a motion to compel arbitration. All right, pretty gutsy move, Pedro, rejecting the payment plan, settlement, and going for arbitration. Looks like the hearing was reset for next month, and we're going back in 2 days. My question is, what should I do next? Should I email the lawyer and tell him that I've been waiting for the lawyer to file arbitration with AAA or AAA, American Arbitration Association? Not to be confused with the guys that do the car stuff. So I can defend that. Any advice or help will be greatly appreciated. God bless you. Thank you, Pedro. Appreciate that. So just recapping, right? So he's being sued for $1,600. He's filed arbitration. He's responded to the lawsuit, probably. If you haven't filed with an answer document already, you should definitely do that just to cover your bases. And then arbitration is a bit interesting, right? So arbitration it's certainly a tool that is available to consumers. It's not something that we're currently recommending at Solo, because we found that most people want to settle the debt, and usually that is going to be like the best outcome in like the litigation process for people who are coming to Solo. I think like settlement's a good option, or bankruptcy can be a great option as well. But like something along the lines of actually resolving the debt is best, right? Arbitration, if somebody actually owes the debt, let's say I'm being sued for like a $10,000 debt, credit card debt. I actually owe the debt. I take out the credit card.
Yep.
I'm being sued for it now. Filing arbitration can be it's essentially like a delay tactic, and is an attempt to win on a technicality. Right? Arbitration, which if somebody actually owes the debt, so let's say I'm being sued for like a $10,000 technicality debt, credit card debt. You probably won't actually owe the debt. You'll probably just get the case. I'm being sued for it now. Filing arbitration can be it's essentially like a delay tactic, and is potentially a win on a technicality. Prosecution, because the person suing you doesn't want to go through arbitration. That doesn't mean that they can't collect on the debt outside of court. That doesn't mean that you don't owe the debt. Also doesn't mean that they can't take that debt and then resell it to like the junkiest debt buyer on the street who will then try to come after you again on it, right? Even after the statute of limitations has expired, they can still take that debt, package it up, sell it to a dude, right? Until eventually, it could potentially just wind up in like the guy with an Excel spreadsheet who bought a portfolio of debts for $50 and is going to try to collect on them. Right, and you don't want to be in that boat. So usually resolution is best, and resolution in this case, if you actually owe the debt, is probably going to be either settlement or bankruptcy, and arbitration is not going to get you there. So if you don't owe the debt, on the other hand, Pedro, if like you're being wrongfully sued, yeah, arbitration can be a great option, right? If it's a matter of identity theft, going to arbitration will help you avoid all of the like pitfalls of litigation that get people. Anything you want to weigh in there, Ben?
Yeah, only to say that like your objective, you have two objectives if there's a debt lawsuit. One is to get rid of the lawsuit because that can have significant consequences, and the other is to get rid of the debt. And they're not always the same thing, right? Like, so arbitration may very well get rid of the lawsuit and not the debt. So it's important to figure out an option for both of those things. And if you do end up, say, filing bankruptcy, that lawsuit will end effectively immediately, unless there's some instance of fraud or something. So it can help shortcut the whole process and get a better outcome than arbitration might.
Right. Fantastic. Okay, we have time for one more question.
Answered a couple in the chat here. I don't know if you have one that you want to cover already.
Yep. I saw the question, the answers to the live questions are fantastic. So we got one more question here from Sandy in California.
Mhm.
So the bankruptcy one. I filed bankruptcy in 2019.
Mhm.
It got discharged in April 2020.
Mhm.
Yep, good move, Sandy. I was challenging the accuracy of the reporting about some of the accounts that were included in bankruptcy. The result was that the accounts updated to charged off. I then filed a complaint and demanded removal. It took about 60 days, and the bank corrected the reporting to include the bankruptcy and removed the payment history box. But Bank of America, another creditor, reported a status of included in bankruptcy. Do you know what that means exactly, Ben? Do you know what that means, like status of included? Is that a thing in bankruptcy?
So it likely means that it was discharged in your bankruptcy. So they were listed as a creditor. They were informed of your filing. They were given a notice to appear at your 341 meeting to object. Maybe they did, maybe they didn't. I'm not sure I'm following whether it was discharged or not. Maybe I'll listen a little bit longer and we can figure out what the question was.
Yeah. So then the payment history box shows 120 days late in April 2020. And then just kind of get into the question here. They continue to fail to correct or remove the account. What can I do? Can they sue me, or can I sue them?
Yeah.
She's asking, can I sue them?
Great question.
Good.
So if it was actually included in your bankruptcy and it was actually discharged, meaning it went away entirely, which you should figure out first. I would look at your bankruptcy filings. I would, check in with the creditor or the agency and see if you actually have an active account with them. And if all of that is, negative, like it was discharged, you don't have an active account and they're still reporting it, there are definitely laws that protect you. That's a pretty severe violation of the Fair Debt Collection Practices Act. I would definitely suggest speaking with an attorney in that instance, because they're not allowed to report that to the Bureau.
Right. So if I understand things right, just summarizing for everybody here, Sandy is saying she filed for bankruptcy, but instead of some debts being reported as charged off on her credit report, instead of them being reported as discharged on her credit report, they're reported as charged off. And she's trying to get that removed. Is that pretty much what you understood there, Ben?
Yeah, that's what I understood too. And like I said, I would make sure that those debts were in fact discharged in bankruptcy. If they weren't, there likely isn't anything that you could do here, given how long ago that bankruptcy process was, and you would need to do something else to address those debts now.
Oh, well, if she filed if the debts were open at the time she filed bankruptcy, then they would have been included in the bankruptcy, right?
They should have been. There's a small chance, it doesn't happen very often, but there's a small chance there was an error. Like if you didn't list the creditors on your forms, or they contested the bankruptcy and the trustee excluded them from the proceedings or something like that, there's a chance they would survive, but that doesn't happen very often. Usually you make a best faith effort to get everything on there, and then all of the debts that you currently have that are dischargeable go away. So I would definitely suggest that you reach out to a bankruptcy attorney about this. Sounds like a pretty complicated situation and not something I would suggest handling on your own.
Right. And just a little insight into the deep part of the process here. So the credit bureaus kind of are playing a crucial role here, right? So how your credit report works is you have the credit bureaus. You have 3 credit bureaus in the US. And a collector who is responsible for a trade line, a debt, reports statuses to the bureau, and then that bureau makes that report available to you as well as to lenders.
Mm-hmm.
The bureaus are companies. They're large companies that I believe, at least in some cases, are publicly traded in the U.S. and they aren't like a government entity.
Mm-hmm.
It's not it's not exactly their main thing, like to make sure everything is correct. They're essentially a reporting platform for collectors to report stuff to, which is why oftentimes it's up to the individual
Mm-hmm.
to dispute the status of a trade line.
Mm-hmm.
Um, Ben, how does that work in bankruptcy? So when you declare, after you've declared bankruptcy, it's still up to the collector. Like the collector's notified that bankruptcy has occurred, and then it's up to the collector to report that it's discharged to the credit report.
Yeah, so they're required to cease delinquency reporting immediately when you file bankruptcy.
Legally required.
Yeah, legally required. Exactly. Like they could do whatever they want. It's not a good idea. There's tons and tons of fines. I think last time I checked, it was like $10,000 per errant report. So this has been going on since 2020. Like that's a huge fine if in fact there was a bankruptcy in which that was included. Post-bankruptcy, they're also required to report this as discharged if in fact it was discharged, which is what we have to confirm. And then if they're reporting it and it was discharged, that's where you have a potential lawsuit. It would be wise to talk with a bankruptcy attorney.
Right. So they're required to report that it's discharged to the bureau.
Yep. Exactly.
However, right. And it's not, my understanding is it's not the bureau's problem if it's not accurately reported, right? The bureau isn't on the hook.
Correct. If the bureau made a mistake, that's a different thing. I doubt that. Like they very often, it's pretty automated how they get things reported. It's most likely the creditor if there was a mistake. But if it was the bureau, you should be able to file a dispute with the bureau. Pretty easy process. A lot of them you can do that directly on their website and see if you can get it taken off that way.
Right. Yes. And right, so I point that out because sometimes people pretty regularly mistakenly assume that there's a referee in this process. And like any part of the process, right? They might think the judge is the referee. They might think the bureau's the referee. They might think some government agency is the referee. Nobody's the referee in your individual case, right? It's an advocacy process. You're advocating for yourself. Collectors advocating for themselves. There's no referee. You can bring things to a judge and then the judge will make a decision. But usually judges aren't going to proactively intervene in stuff.
Yep.
Federal agencies, like the FTC, for example, like do proactively intervene in stuff, but they only intervene on like a large scale, right? They aren't going to like intervene in your one little case. They might play referee in a larger scale on many, like thousands or millions of cases, but they aren't going to intervene on your little your case. So yeah, that's an important thing to point out, right? So Sandy, if you're seeing that somebody's erroneously reporting to the bureaus, yeah, you definitely want to take action to make sure that things get wrapped up, right? Maybe there's an error. Maybe there's something that you're missing on your part. Maybe like these debts aren't actually, maybe they actually weren't discharged in bankruptcy, right? Maybe they're debts you had after the bankruptcy occurred.
Possible.
Yep. Maybe they are debts that were discharged in the bankruptcy and you just need to get them removed. I'm sure the bureau, if they are debts that were discharged in your bankruptcy, the bureau will be happy to fix that for you. Also, the collector, I'm sure, will be eager to fix that as well instead of getting fined.
Yeah.
Okay.
And Sandy, if you want help with this, if you email help@upsolve.org, our paralegals can take a look at that and see if they can assist you in pulling the credit report and figure out what's going on there.
Love that. Love that. Okay. Well, fantastic. Folks, this is the Debt Hotline. Mistakenly, you've been listening to me. I'm George, founder of Solo, and Ben Jackson with Upsolve. Fantastic. Ben, awesome. Thanks so much for coming on the show.
Yeah, awesome. Great being here. Thanks so much for having me. And everybody out there, that if you're struggling with debt like I was, there's definitely hope, whether that's Solo, whether it's Upsolve, we've got you.
Alrighty. Have a good night, everybody. Take care.
See y'all.